Welcome to the committee. I believe this is Kate Fitzpatrick on the line.
Correct.
Welcome. You have 3.5 minutes to testify. You may begin.
Thank you. My name is Kate Fitzpatrick. I'm here to support Bill 527 in preventing high heat medical waste facilities from doing irreversible harm to the communities and residents of Rhode Island. I am a resident of Warwick, where I bought my first home 3 years ago and hope to raise a family here someday. I have a bachelor's of science in biology and have spent the last 10 years as an environmental scientist here in our beautiful state. The technology of reducing waste by high heat may take on different forms. However, what remains behind is always the same. It's ash, the same type of stuff you would find in an ashtray, fireplace, or wood stove. It's messy and difficult to contain. It's composed of fine particulates which are highly mobile in air and water. Although high heat can destroy pathogens and reduce the volume of medical waste, toxic metals accumulate in the ash. Looking at peer-reviewed studies specific to medical waste ash in Greece, India, and China, data consistently shows significant levels of toxic metals, such as lead, cadmium, nickel, copper, titanium, and zinc. This data also indicates that metals become soluble and mobile, posing a serious threat to surface and groundwaters. To take a quick look at some numbers, medical waste ash from a study in Greece contained over 2,000 ppm of lead. To give that some perspective, anything over 100 is considered hazardous waste, and the EPA action limit for lead in drinking water is 0.015 ppm. The second point I want to highlight is while high heat facilities can reduce the volume by 85 to 95%, this only translates to 75 to 85% reduction in weight. This is an important distinction as our permitting and landfills are based on weight. Simply put, ash doesn't take up much space, but it's heavy. While a company may boast a 95% reduction to our landfills, we should take a closer look. Taking in 70 tons of medical waste a day, as currently proposed by MedRecycler, would produce 74 to 123 tons of toxic ash a week. This quantity of waste would need to be stored until it has been tested, transported, and disposed of. I think these numbers speak for themselves. The significant environmental and human health impacts of allowing high-heat medical waste facilities to operate in Rhode Island far outweigh any benefits. And I strongly encourage you to support Bill 527 in preventing this harm from occurring. Thank you.
Thank you for your testimony. Any questions of this witness? I don't see any questions at this time. Thank you for joining us this evening, and thank you for your testimony.
Thank you.
Welcome to the committee. I believe we have Denise Lopez on the line. Is that correct?
Yes, it's correct. Thank you.
Welcome to the committee. You have 3 minutes and 30 seconds. You may begin your testimony.
Okay, thank you very much. Will it cause cancer? What impact will it have on our water supply? Should I move? Will it smell? How did it get here? These are questions I get asked daily as I've been working on the opposition for the medical waste, high heat medical waste facility, MedRecycler, currently proposed for Kent County. From discussing with the company and with residents in New Mexico, the way that the companies come in is all the same. It's under the radar to unsuspecting communities. In our case, it's a working class community looking for the benefits of the tax revenue and promise of jobs. The only issue is the location also happens to be in the middle of Kent County with no buffer zone, a neighboring daycare, college campus, and numerous businesses and residential communities. There are 70 employees on the other side of the wall to the business where MedRecycler is proposing to set up. And the other fact that can't be ignored is that they would also be looking to bring more waste into the state of Rhode Island from neighboring states in order for their business to be profitable. Many companies will be looking to come into Rhode Island claiming to be green with no concern for our welfare, just the bottom line. And this is not a NIMBY issue, as I've been told many times. I just don't want it in my backyard. I don't want it to be anywhere in Rhode Island, and Rhode Island needs sustainable industry, not pop-up ones that typically shut down due to environmental concerns, fines, or finances needed to further support the safety of their initiative. After spending over a year objectively trying to learn about these types of facilities, the concerns stated are real, and quite frankly, Rhode Island is too densely populated a state to take a chance with any environmental or health concerns the public would be subject to with a high heat facility. With Rhode Island government officials looking to reduce emissions and help protect our beautiful state and all who live here, it would be counterproductive to allow high heat facilities to operate in Rhode Island. I urge you to move forward with support of this bill to help protect all of Rhode Island communities from going through the worry and concerns our residents are currently facing. And I don't know if it's allowable or permissible, but I would also like to say my objection or opposition for Bill 254, which is pro burning of plastics, because again, as many have stated, we're just too densely populated a state, and the risks are just too great of a burden to bear. Thank you very much.
Thank you very much, Ms. Lopez, for your testimony. Any questions of committee members? Seeing none at this time, thank you again. Welcome to the committee. I believe we have Peter Trafton from the Environment Council of Rhode Island joining us now. Good evening, sir. You have 3.5 minutes for your testimony.
Thank you very much. Can you hear me okay?
Yes, and is this Peter Trafton?
Yes, it is.
You may begin your testimony.
Thank you. So I'm from Providence, supporting S527 on behalf of the Environment Council of Rhode Island. As my esteemed colleague Greg Garrett has already mentioned, he was too. And I'm speaking on behalf of the more than 60 organizations in ECRI, the Environmental Council of Rhode Island, for 527. I'll also be mentioning briefly S254 in opposition to the bill. So ECRI has reviewed 527 and determined to support it because of the many problems of waste incineration generally, the serious risks and minimal benefits of high heat waste processing, and our state's long-standing policy of not allowing waste incineration of any kind. Emissions from burning plastic, as you've heard, are dangerous. They're inevitable. If you burn them, they're burned. No matter what name is applied to the technology and what temperature is used. While we do have a waste crisis, especially related to plastics, incineration is not an appropriate answer, and it continues to fail the marketplace test. You just heard how well the plants are not doing that tried to do this in other states, and almost all of them have eventually gone out of business. It does not pay to try to recycle plastics. Regrettably, petrochemical producers are flooding America with claims that support the so-called advanced or chemical recycling. They do this to sell their plastics as reusable. However, turning plastic into fuel and then burning that fuel is chemically and ultimately the same as burning plastic, with dangerous emissions and no significant energy benefit. The few such facilities that have been put into service have been economic and environmental failures. Rhode Island needs S527. This is clearly demonstrated by current efforts to establish the high heat incinerator for medical debris, medical waste in West Warwick. 70 tons a day gathered from all across New England. This project has somehow progressed through several steps of permitting and state funding approval without establishing its safety and financial viability. Little cart before the horse. To avoid more of these attempts and to preserve Rhode Island's environment, please approve passage of S527. Providence has, as you've heard, recently banned high heat incinerators. The state of Rhode Island should follow suit. Finally, regarding S254, which is a workaround to sneak plastics past a ban on waste incineration, it certainly deserves your rejection. Thank you, Senators, on behalf of ECRI. Good day.
Thank you. Thank you so much for your testimony. Any questions of this witness? Yes, Senator Burke has a question for you, Mr. Trafton.
Yes.
Senator Burke? You are muted, Senator Burke.
I'm sorry. Thank you.
You may.
I have a question. Where is DEM stand on this? I mean, they have to permit this stuff.
You're breaking up badly, Senator. I'm sorry, I could not understand your question.
How about now? Can you hear me?
Yes, much better.
Okay. Where does DEM stand on these facilities? Because they have to permit them.
The question that you have about DEM and where they stand is I don't know what their policy is overall with regard to legislation about banning all forms of high heat incineration, which is what this bill is about. With regard to the medical waste incineration, that is still under review. They have had extensive and well-documented hearings, and that information is available, but they have not made a final decision yet, sir.
So they have a final say on this right now?
They have a pending application which requires their approval. There actually are other approvals that are going to be necessary, apparently, such as the local jurisdictions in West Warwick and so forth. But again, this is still a matter that's pending before DEM and other state and local bodies.
Okay, thank you.
Thank you, Senator Burke. Any other questions of this witness? Okay, seeing none at this time, thank you so much, sir, for your testimony.
And thank you again for the opportunity. Good.
Sure thing. Next, I believe we have Jonathan Barad from Clean Water Action. Welcome to the committee, sir, and you have 3.5 minutes of testimony.
Thank you, Chair Coyne and members of the committee. My name is John Berard, and I am the Rhode Island State Director at Clean Water Action. I speak today on behalf of our nearly 20,000 members here in Rhode Island. We strongly oppose S254 and support S527, and we thank Senator Valverde for her leadership on this issue. I submitted some written testimony with more extensive remarks, but I'm going to briefly touch on a couple things tonight. First, high heat facilities will not alleviate the waste management burdens for Rhode Island municipalities that we already have. Towns and cities will still be responsible for the collection and transport of these products. In fact, there will have to be an extra step to sort items that will go to the MRF and those that will go to these so-called advanced recycling facilities, plus additional costs associated with transportation, tipping fees, and fines. When I talk to recycling coordinators and solid waste managers here in Rhode Island, the thing we hear over and over is that they are struggling to keep up with the waste they are dealing with now and the cost for contaminated recycling. Second, they will not solve our litter and plastic pollution problems. The permitting of these facilities will not prevent littering. They will not prevent plastic from being blown out of recycling bins. They will not prevent accidental spillage from recycling carts or dumpsters. They will not prevent plastic that ends up outside of the waste stream from ending up in the environment, our neighborhoods, and our waterways. And so now for what they will do, they will make both of these problems worse. We are seeing these proposals from the petrochemical industry not because they are sincerely trying to help us solve our plastic pollution crisis or extend the life of our landfill. They do not care. They are bringing them forward because they have their wagons hitched to increase plastic production, which they are forecasting to triple from current rates by 2050, as a way of finding something to do with all of the oil and gas they plan to continue to extract as the global economy turns to renewable energy. These facilities are expensive to operate, as we've heard. They require a steady stream of plastics to feed the beast. This means more plastics entering the economy, more burdens on Rhode Island towns and cities, and more nuisance plastic pollution in our communities in the Bay. This is the industry trying to externalize the environmental, social, and economic costs of the growing mess that they plan to continue to saddle us with. Any community where a facility like this would be located, like my colleague Greg Garrett mentioned, would become an environmental justice and public health sacrifice zone. Now, if you have a busted pipe in your house and your basement is flooding, it doesn't matter how many pumps you have or how new or flashy or quote-unquote advanced they are, your basement is still going to continue to fill with water until you shut it off at its source. Likewise, recycling is not the solution for our problem here, whether we're talking about mechanical recycling like we already have at the MRF or the quote advanced processes being pushed by industry. Our solutions lie upstream by turning off the stream of unnecessary plastics from ever ending up in our economy in the first place through source reduction and extended producer responsibility laws, much like the bag and straw bills that this body passed earlier this week, and I thank you for those votes. For years, industry has pushed a narrative that blamed end users for the system's failure, placing fault on municipalities and people that don't recycle properly or, quote, don't do the right thing. This is a tactic right out of the tobacco industry playbook, and we cannot be allowed to fall for it again. They are the ones causing this mess, and we are the ones that are left to deal with it and clean it up and pay for it. Clean Water Action, along with our members, strongly oppose S254, and we support S527. We thank you, Chair, and the members of the committee for your consideration of our comments. I'm happy to take any questions or talk about this further at another time.
Thank you. Any questions for this witness? I see no questions at this time. Thank you, sir, for your testimony this evening.
Thank you, Chair.
Sure thing. Welcome to the committee. I believe we have Amy Petrino on the line to speak on 527. You have
Yes, thank you so much.
You have 3 minutes
My
and
name
30.
is-
You have 3 minutes and 30 seconds, ma'am.
Great, thank you so much. My name is Amy Petrino, and I am a resident of East Greenwich. I'm testifying on Senate Bill 527. I am in favor of this bill. I became aware of paralysis back in the spring of 2019 after receiving a letter as an abutter to the facility that is proposed for 1600 Division Road in West Warwick. After doing some basic research, it became clear that paralysis is not what it was what it was told it would be at a West Warwick Town Planning meeting in the spring of 2019. Everything was going to be great, and this was just going to be the most wonderful facility to ever come to Rhode Island. And after asking some questions at that meeting and doing some basic research, it became clear that it is not safe. It's not safe for the residents, the environment. It is not safe for all of us who live near it. This company is not meeting the guidelines that were outlined by DEM, but they will keep telling you that they're going to be a good neighbor. Their definition of good neighbor and mine vary greatly. During the March 15th DEM meeting this year, 97 people spoke publicly. They were a very diverse group of doctors, teachers, first responders, public officials, parents, students, environmentalists, all with one unified voice speaking out against this project. Only 3 people out of those 97 spoke in favor: the owner, a person selling equipment to this business, and someone who will financially gain from the transport of the medical waste. All of them are set to profit from this risky, dangerous, and untested facility. No one who doesn't have a financial stake in this project is for its existence. In August of 2020, I was diagnosed with cancer. My cancer is likely caused from environmental factors. After genetic testing and no immediate family history, my doctors determined this cancer, which I am currently being treated for, was caused by something environmental. My question to all of you, as our elected officials, is: if you could prevent something as highly toxic and dangerous to the residents of Rhode Island and our beautiful state, why wouldn't you? What is there to prove by letting someone create a facility that could and will cause health issues for Rhode Island when you have the power to prevent it from ever happening? I don't wish the treatments that will save my life on anyone else. Unfortunately, I am not in the position to stop this. My only hope is that you will see how important you all are in keeping all of us in Rhode Island safe. I thank you for your time and the opportunity to speak today.
Thank you for your testimony. Any questions for this witness? I don't see any at this time. Thank you again for your testimony. And so now we are going to move to Senate Bill 521, public testimony on 521. I believe we have Joel Gerstenblatt from Matunic by the Sea on the line. Is that correct?
That's correct.
You have 3 minutes and 30 seconds for your testimony. You may begin.
Thank you. My name is Joel Gerstenblatt. I am a member of the Beach Association located in South Kingstown, Matunic by the Sea. We are opposed to Senate Bill S-0521. Just for background, our association was established in 1953 and is an association of approximately 121 members, including families that own property located near the Green Hills section of South Kingstown. The association is comprised of a number of full-time residents within Rhode Island Senate District 38 and seasonal residents who pay taxes to the town of South Kingstown. The property owners have deeded rights to belong to the association. The association owns a small section of waterfront property in the Green Hill area of South Kingstown. The length of the beachfront depends on the tides. The width is approximately 10 to 15 feet in length from the dunes to the ocean at high tide, and even less when there's a moon high tide. and 50 to 60 feet at low tide, and approximately 150 feet in width. Over the years, the beach erosion has greatly diminished the extent of the beach. The South Shore and the Green Hill area, due to beach erosion at times is reduced to a 10 to 15-foot beachfront area. At times with high tide, especially with a moon tide, there is very, very little beachfront available for members and the public. The bill as currently drafted provides that no person shall be prosecuted for certain protected conduct within 10 feet of the most recent high tide line. Protected conduct includes, but is not limited to, fishing, gathering seaweed, swimming, and passage along the shore. We believe that this bill is overly broad, ambiguous, and vague. The association has never had an objection to individuals passing along the shore. The association has never had an objection to individuals swimming, fishing, gathering seaweed or shells within the parameters of our beachfront. However, as the bill is drafted, does protected conduct include a person who decides to place their beach chair, their coolers, their tents, play volleyball, or touch football, etc., within 10 feet of the most recent high tide line? At times, depending on the tide, protected conduct would be within the entire beachfront of our association. Further, this activity would interfere with the enjoyment of our members who pay dues to maintain the property. The high tide line in that area changes daily, obviously, and differs at different locations along the shore. The high tide line at our location near Green Hill could be different than the high tide line a few miles away at Charlestown Beach. Clearly, all persons should have access to the shoreline. However, in our opinion, the bill as presently drafted infringes upon the rights of property owners along the shoreline. It would prohibit the police to enforce the law within 10 feet of a moving high tide line. Conduct that occurs in one day could be protected under this bill, whereas on the following day, depending on the line, the conduct would be a violation of the law. Also, the bill appears to circumvent the Rhode Island Constitution, which protects the rights of all people to enjoy and freely exercise the right of fishery and privileges along the shore. In our opinion, this does not include the right to occupy private property. We oppose this bill as presently drafted and respectfully suggest that it be revised to protect both all persons who wish to gain access to the shoreline as well as the owners of property along the shoreline. Perhaps the revision should protect the right of individuals to fish, swim, gather seaweed, and passage within 10 feet of the current water's edge. The language, including but not limited, should be omitted. Thank you for allowing us to present our viewpoint.
Thank you for your testimony. Any questions of committee members? Seeing none at this time, we'll move on to our next witness. Good evening. Welcome to the Committee on Judiciary. I believe we have Christopher Boyle representing Starters.
Thank you, Madam Chair and committee members. I represent an association named Starters, which is an association of shoreline property owners, primarily consisting of private owners, nonprofits, commercial businesses, and tourism-related businesses, primarily in the Quinnipiac Island area. We acknowledge, as I think all will, that legal issues relating to shoreline access can be very complex. In fact, as Senator DeMario mentioned, that this goes back to colonial times. In fact, it predates that and has been going on for centuries. The proposed legislation is a rather unique attempt to expand the public trust doctrine to lands not before subject to it. Recognize the complexity of the issue and the uniqueness approach of this legislation. Starters decided to engage an attorney to perform a legal analysis of the statute. We engaged attorney Dan Procaccini of Adler Pollock and Sheehan to provide us with an analysis of the proposed statute. And I know I've submitted to the committee and to the members a copy of the white paper prepared by Dan. And two basic major concerns that were raised in the white paper. One is the issue of void for vagueness, which I will leave to the committee's perusal of the analysis to review. The other one is a review by him of a long line of U.S. Supreme Court decisions which it was opined that the proposed legislation would amount to a taking under the Fifth Amendment of the U.S. Constitution. The U.S. Supreme Court has consistently held that there is a per se taking of property by the government where the government attempts to allow public access onto private property. In fact, there's a Supreme Court case before the court now ready for a decision on this very issue of taking. The proposal before you legislatively carves out a protection under the criminal trespass law to allow 24-hour, 7-day-a-week access by the public onto private property. The U.S. Supreme Court has found similar attempts to be a, quote, permanent physical occupation, close quote, and therefore constituting a taking. The Rhode Island Supreme Court in Ibbotson also determined the public trust doctrine, and as Senator DeMario indicated, it is the mean high watermark average of the last 18.6 years, which is very different from the proposed legislation, which is 10 feet from the latest high tide mark. As such, if this statute would be determined as a taking, the state of Rhode Island would have to compensate the landowners who were subject to this, and I'm sure the committee can imagine that this would be an astronomical figure that the state would be responsible to pay. There's one other issue I just want to bring up that Senator DeMario mentioned. That is the issue of liability. The recreational use statute in Rhode Island does provide protection from liability, but only where the public has been invited by the landowner to be on the property for recreational purposes. So I don't think it would apply in this circumstance. Thank you, Madam Chair. I would leave a more complete information review to the analysis that we provided to the committee. I appreciate your time.
Thank you very much for your testimony. Any questions of Chris Boyle at this time? Yes, Senator Reptakis.
Madam Chair, on Chris, if I might ask, Mr. Boyle, did you say that in her bill, Senator DeMario's bill, it would allow the state to, or force the state to take property over current property of those that are part of the shoreline?
Yeah, right. The present constitutional standard, which the Rhode Island, both the United States Supreme Court and Rhode Island, has determined that the property line, is the mean high watermark over the last 18.6 years. This bill would say move that line up to the latest high tide mark plus 10 feet. So yes, this would expand public access onto actual private property.
But does it force the state of Rhode Island to compensate those owners?
Well, we believe that this constitutes we believe this constitutes a taking. That the court would find that when the state says you must allow people to access your private property, we believe under the Fifth Amendment of the Constitution, under the Rhode Island Constitution, that would constitute the government taking your property. And we believe
it's not eminent domain. Would it be something like eminent domain where you'd be taking the property? Because I'm not sure if that language is in the bill, because you're stating that the bill says that the state of Rhode Island would be responsible and a burden to the taxpayers of the state by being forced to pay compensation or take over that property. I just want to make sure that's a clear statement that you made, that that's what's in the bill. I'm just being very careful on hearsay and not actual fact.
No, we believe, it's certainly not a provision in the bill, but we believe it's a consequence of passing the bill.
I see.
That
thank
someone
you.
would litigate the fact that they would be taking land. The government would be, per se, taking the property, by which, under the Fifth Amendment, the state has to compensate for it.
Thank you. Any other questions of committee members? Seeing none at this time, thank you for joining us this evening. We will now move to the next witness, which I believe is Stephanie Roberg. Good evening. Welcome to the committee. Do we have Stephanie Roberg on the line?
Yes.
Yes, you have 3 minutes and 30 seconds, ma'am.
Thank you.
You may begin.
Oh, okay. There's somebody speaking.
You can lower your television audio in the background. Okay. There is a delay.
Got it.
You may begin,
yes.
please.
Yes. Thank you, Chairwoman Coyne and members of the Judiciary Committee. My name is Stephanie Roberge. I'm a beachfront property owner in South Kingstown. I have which borders Charlestown Beach. I have submitted written testimony, and I am, and I would like to address my verbal testimony to some of the remarks that have been made earlier this evening by Senator DeMario. I am also an attorney and have analyzed the bill. And just as was described as the previous witness, the bill as written does not describe what Senator DeMario has described by providing for no trespass above the most recent high tide line. There are 2 high tides during the course of the day, and that can encompass essentially on our property close to 80 to 100 feet of private property beach that would be accessible by the public. During the commentary, Senator Archambault referenced the public trust doctrine, and in quickly looking that up, the public trust doctrine is codified in the Rhode Island Constitution. And the Rhode Island Constitution describes that the public has the right to access along the shore. And that along the shore is defined as the land along the edge of the sea. So that is where the confusion is. The land along the edge of the sea is the area that's protected under the Rhode Island Constitution for members of the public. And hundreds of people, thousands of people across this state access the shore in that way. In front of our house and in front of the beaches along the shore, people are allowed to walk. They freely walk, they freely swim, they freely gather seaweed all throughout the year. No one is prevented from doing that. In fact, there have been essentially no trespasses statewide, and most beach communities actually have a policy of not making arrests on the beach. I've referenced that in my written testimony. There are also no blockades for access for people to walk along the beach. As a matter of fact, if there are blockades, if people do try to erect blockades, CRMC will actually contact the landowner and tell them to remove it. So there is no blockages of lateral access. In addition, the mean high water mark is not only defined by the Rhode Island Constitution, the mean high water mark is defined in the Rhode Island statutes under 46-23 as the property boundary. Also, under the Iverson case, the mean high water mark has been, by the Rhode Island Supreme Court, has clearly been determined as the property boundary. What this bill actually does is it provides the public access to private property for use that goes well beyond the public trust doctrine, well beyond the Rhode Island Constitution, and well beyond both case law and statutory law that exists in the state of Connecticut, in the state of Rhode Island. And what will happen, and if I may address the concerns of Senator Rapkakis.
I'm sorry, you cannot at this time, unless a committee member has a question. Your 3 minutes and 30 seconds is finished. Stand by. We'll see if any committee members have any questions. Any questions at this time? Seeing none, you did reference that you have written testimony, and if you want to submit additional written testimony, feel free, you may. But now we must move on to our next witness, which is Michael Foley. Oh, okay. I'm sorry, it should be Lana Browning. Good evening, welcome to the committee. Is this Lana Browning?
Yes, it is.
Good evening. You have 3 minutes and 30 seconds for your testimony.
Okay. Again, I'm Lana Browning. I'm fortunate enough to have oceanfront property. It was purchased as a piece of property totally, just like private property is inland. And I believe it should be only used by the people that pay for the purchase of it and for the taxes. I know that there is a outstanding situation right now with people thinking they should be able to have access to it. I think the rule where they can walk, they can swim, they can take seaweed is about what they should do. That law also says that they should not be stationary. I don't think they should be stationary, although my property, I've had up to 300 people on it. I don't think that is right. I have paid for the property, as other people have, and just because we're fortunate enough to be on the ocean doesn't give anybody the right to decide to use our private property. So I would vote no, because I believe what is private, whether it's in town or on the ocean, is exactly that. It's private property that we have paid for. And I don't think that the general public should just be able to sit on our property any more than it should be able to sit on a lawn in town. So again, I vote totally against it. I think it should be monitored by the police like any other area that is owned privately should. And I don't think the law should change, and it should be adhered to, and it should be supported by the police department if someone is on private property, whether it's in town or on the ocean. So again, my vote would be no changes.
Thank you, ma'am, for your testimony. Any questions of this witness? Seeing none at this time, thank you for joining us this evening.
Okay, thank you.
Thank you. Welcome to the Committee on Judiciary. I believe we have Michael Foley on the line. You have 3 minutes and 30...
Yes, how are you?
Hi, welcome. You have 3 minutes and 30 seconds for your testimony.
Okay, great. I'm a homeowner on Charlestown Beach Road in South Kingstown. I own a home with a private beachfront, and I wanted to voice my opinion that the bill was problematic to me and my family, mainly because of the precedent it's going to set for allowing people who don't own the property to basically, without restriction, use our property. I'm concerned about the liabilities associated with that. I'm concerned about the possibilities of damage to the property, which right now is maintained by us. We're taxpayers on the property, so we've maintained it well, and it does include dunes, which are protected by coastal, which every year when there's problems, we put up fences, and dune fences all regulated by the state. So the beach, in fact, right now is about 10 feet from the dunes, and so if you made the line 10 feet from the high water mark, you'd be talking about basically the entire beach as it exists now, and it just doesn't really work. Meanwhile, there's no need for a law because people are allowed to freely pass as they want to, and we've never had a problem. Hundreds of people walk past their beach and pick up seashells and enjoy the beach. We have no problem whatsoever with that, but we do have a problem with the law that permits people to basically do whatever they want on our property. There's no restrictions in the bill, as I read it, that set stipulations on what time people can be there, what they can do, bonfires, parties, etc. It's basically our front yard, and I'm sure if you think about it from the standpoint of a homeowner whose front yard is being impacted by the bill, you'd see that it's unbelievable to me. It's basically seizure of private property by the government for public use. And it's not only that, it's property we pay taxes on. So that's my basic set of concerns, and I appreciate your time.
Thank you very much for your testimony. I don't see any questions by committee members at this time. Thank you again for your testimony.
Okay, thank you.
Good evening. Welcome to the Committee on Judiciary. I believe we had Jeff Thorpe from Save the Bay on the line.
Thank you, Madam Chairman. This is Jed Thorpe. I'm the Advocacy Coordinator for Save the Bay. And our mission, as you probably know, is to improve and protect Narragansett Bay. And having a clean and healthy bay is really of little value if the public isn't able to enjoy it. So public access to the shoreline is a very important issue for us and our members. First of all, we don't believe that a person who's fishing, gathering seaweed, or passing along the shore on land above the mean high tide line is necessarily trespassing under current law. Now, the state constitution specifically protects public access to the shore, and as Senator DeMario mentioned in her comments, these rights have been recognized under various theories and go back to the 1662 charter that established our government. One commonly applied interpretation of the public trust doctrine in Rhode Island uses the mean high tide line, which is the average of high water heights observed over an 18.6-year lunar cycle, as other people have mentioned. Now, while that very highly technical scientific definition, which comes from the Supreme Court Ibbison decision back in 1982, that might be appropriate for ascertaining the finer points of property ownership over the periods of years, it's nearly impossible for the average beachgoer to use when exercising his or her constitutionally protected right to access the shore on a day-to-day basis. The Rhode Island Constitution, which I should point out was amended in 1986, 4 years after the Ibbison decision, and very much so with the Ibbison decision in mind, the language in the Constitution recognized that the exercise of public trust rights might include use of land above the high tide line. And we have more about this in our written comments on this point. And I think it's important because folks have mentioned the Constitution to actually read the section that people are referring to, and I'm just going to read it briefly. And it says, quote, "The people shall continue to enjoy and freely exercise all the rights of fishery and the privileges of the shore to which they have been heretofore entitled under the Charter and usages of this state, including, but not limited to, fishing from the shore, the gathering of seaweed, leaving the shore to swim in the sea, and passage along the shore," end quote. Now, given that neither boundary from the Ibbison decision or the language in the Constitution is readily discernible to the average citizen, criminal prosecution in this area is wholly inappropriate. And in order to both protect the rights conveyed by the Constitution and give the public the ability to recognize adjacent private property interests, we feel that the legislature needs to provide a visually recognizable line that ebbs and flows with the daily whims of the sea, and we feel that this bill helps to do that. It's also been mentioned that this legislation could amount to a takings. Again, this bill does not change the property line, where the property line is. It's our contention that the public's right to walk along the shore, that public easement, if you will, that crosses onto people's private property, it's not a takings because that right of the public has always been there. So you can't take something that you've always had. Lastly, we are concerned that the amendments to existing law proposed in this bill might be interpreted to diminish public trust rights, and we recommend that the legislation be clarified to state that nothing set forth in this law shall diminish public trust rights guaranteed in the Rhode Island Constitution. And we thank you for the opportunity to testify, and I'm happy to answer any questions.
Thank you very much, Mr. Thorpe. Are there any questions from any members of the committee? Mr. Thorpe. Hearing none, thank you. You have a nice evening.
You too, thank you.
Thank you. Our next caller is Judy Thomas. Good evening, Ms. Thomas.
Hi, thank you. My name is Judy Thomas.
You have
I live on
3 minutes. 3 minutes and 30 seconds, please. Go ahead.
Oh, thank you. Thank you. My name is Judy Thomas, and I live on Charlestown Beach Road in South Kingston. Thank you for allowing me to speak tonight to voice my opposition of Bill 0521. The bill isn't needed because the public already has access to the shoreline for all the stated activities in the bill: fishing, gathering seaweed, swimming, and passage. Each and every day I watch hundreds of people participating in these activities directly in my front yard and up and down the coastline. I ask of you to think about the many repercussions of allowing people to trespass on private property with no remedy for property owners. The issue has never been about fishing, seaweed collection, and passage along the shoreline. That isn't the issue because no one is denied from doing those things and never have been. The real issue at hand is what people want to use the private beach property as their own. They want to use it to set up camp, to bring their animals, and to drink their alcohol. All the things that are not allowed to be done on the town and state beaches in Rhode Island. This bill prevents enforcement of property owners' rights and is unlawful, uncompensated seizure of private property. It is a common occurrence everywhere, but especially along the coastline during the summertime when people often overindulge in alcohol, act disorderly, vandalize private property. Property owners along the shore shoulder a significant burden because public beaches, both town and state, have rules against such behavior, and they are aggressively enforced. Bill 0521 will massively amplify this situation because it eliminates a property owner's right to enforce trespass on the very property they own. In addition, the bill shifts an immeasurable liability directly and unlawfully on property owners. The bill provides access to private property within 10 feet from the most recent high tide line versus the current mean high tide methodology. The proposed methodology is 100% unmeasurable, changes 2 times a day, is impacted by weather, and is 100% subjective. Can anyone define how to measure the most recent high tide line? The answer is no, because the most recent high tide line changes every day and changes throughout the day as the tide comes in and out. The collection of drifted seaweed scattered along the beach is by no means a boundary line to determine the line of demarcation. With Bill 0521, there is no way to establish an official boundary. We must keep in place the existing law because the mean high tide methodology is 100% measurable. In the presentation tonight, Senator DeMario mentioned wet sand as a boundary marker. What happens if it rains? It just doesn't work. In addition, Senator DeMario mentioned no trespassing signs. These signs have been popping up, but do you want to know why? Because of bills like 0521. The public has now become emboldened to help themselves to private property for more than just swimming, fishing, seaweed collection, and passage along the shoreline. And lastly, Senator Riptakis asked an excellent question. Are you allowed to walk up and down the beach? And the answer is absolutely yes. No one has ever been denied to walk up and down the beach or to fish or swim or collect seaweed. We don't need this bill to accomplish that. For these stated reasons, I oppose this unneeded legislation, and I respectfully request you to vote no to Bill 0521. Thank you for your time.
Thank you very much. Is there anyone who has any questions for this witness? No, hearing none. Thank you. You have a nice night.
Thank you.
Thank you. We had several more witnesses, but we've been unable to reach any of them. So we're going to move on to our next bill, Senate Bill 531. And our first witness is Vicky Katrinik from the Humane Society of the United States. Good evening, Ms. Katrinik.
Hello.
Hi, yes. Welcome to the committee. You have 3.5 minutes to testify, and you may proceed.
Thank you so much, Vice Chairman and members of the Senate Judiciary Committee. My name is Vicky Katrinik, and I'm the Director of Animal Research and Testing at the Humane Society of the United States. I appreciate the opportunity to testify in support of S531. This legislation prohibits the sale in Rhode Island of any cosmetics subjected to new animal testing. S531 does contain some limited exceptions that allow for animal testing under certain conditions, including testing done to satisfy regulatory requirements and to address specific and serious human health concerns. There is strong support from corporations for ending cosmetic animal testing. S531 has received letters of support from cosmetics manufacturers and retailers in the state of Rhode Island, including Lush, Pure Eco Spa and Boutique, and Solita. Last Congress, federal legislators considered the Humane Cosmetics Act, which would end production and sale of animal-tested cosmetics in the U.S. This federal legislation also has the support of the Personal Care Products Council, which represents 90% of the U.S. cosmetics industry. And in addition to the 600 member companies of this organization, 336 individual companies have also endorsed the federal effort. And S531 was drafted to mirror the provisions in this federal legislation. In traditional animal tests, rabbits, guinea pigs, mice, and rats have substances forced down their throats, dripped into their eyes, or smeared onto their skin before they're killed. But it's important to note that there are no animal test requirements for cosmetic safety substantiation in the U.S. Companies can use thousands of available ingredients that have a history of safe use and do not require any new testing at all, animal or otherwise. For new ingredients, there is an enormous array of non-animal methods available for use, and new methods are developed every day. These new methods represent the best that science currently has to offer. They deliver human-relevant results more quickly and often at lower cost. And that is why cosmetics companies have embraced these new tests. And there's been a global trend toward eliminating cosmetic animal testing. There are now 4 states that have banned the sale of animal-tested cosmetics: California, Nevada, Illinois, and Virginia, which passed a law earlier this year. Similar bills are also on the governor's desks in Maryland and Hawaii, and others are being considered and making progress in Maine, New Jersey, and New York. In 2013, the EU finalized its ban on the sale of cosmetics tested on animals. This ban compelled cosmetic companies to end the use of animal testing and instead invest their time and resources in the development of non-animal methods. 40 countries now have laws to end or limit cosmetic animal testing. The Humane Society of the United States strongly supports S531, and we urge the committee to pass this legislation. At this time, I'm happy to answer any questions.
Thank you very much. Are there any questions from any member of the committee? Hearing none, I thank you very much for your testimony, and you have a nice evening.
Thank you, you too.
Thank you. We're moving on to Senate Bill S-534, and our first witness is Stacey Ober from the American Kennel Club. Good evening, Ms. Ober.
Good evening.
Yes, welcome to the committee. You have 3.5 minutes to testify, and you may proceed.
Thank you. Good evening, Madam Chair, members of the Senate Judiciary Committee. My name is Stacey Ober, and as the government relations advocate for the American Kennel Club here in New England, I am testifying this evening in opposition to Senate 534 and Senate 601, the Lawyers for Animals bill. The AKC is a 135-year-old not-for-profit animal welfare organization that is recognized and trusted as an expert in canine health, breeding, training, and responsible dog ownership. We're celebrating the funding of more than $59 million in canine health research that benefits all dogs, and we represent more than 5,000 kennel clubs nationally, with 10 in Rhode Island. I want to say first that the AKC supports enforcement of the Rhode Island animal cruelty laws. Those who treat dogs in a negligent or cruel manner should be held accountable. Under Senate 534 and Senate 601, they would authorize the criminal and civil courts to appoint a volunteer lawyer or student lawyer to represent an animal in the interest of justice. This change would dramatically change the current legal framework that actually protects pets and the public. For centuries, our legal framework has regarded animals as property, and this legal principle allows the legislature to impose strict liability on an owner when a dangerous dog causes injury to another, to hold owners accountable to provide standards of care, shelter, and nourishment for their animals, and to even penalize individuals for theft of a dog or some other crime. What you may not know is there are animal rights organizations that repeatedly file lawsuits in the name of animals. And their publicly stated goal is to provide animals with legal rights and eventually prevent the breeding, ownership, and use of animals, even as a source of food. Uniformly, the courts have rejected these cases because animals lack legal standing. In response, these groups advocate changing the law, and I've described their approach in my written testimony to you. What I want to ask is whether or not the committee might consider these questions, which we believe under Senate 534 and 601, animals that would be granted legal representation would imply that they have legal rights similar to humans and legal standing. But if enacted, it would create questions and confusion because the text is vague. So, for instance, the AKC is not aware of any constitution that affords animals legal representation and rights. And under these bills, which animals would deserve legal representation? What animal interests or rights are volunteer attorneys representing? How do attorneys know what an animal wants? Are they substituting their personal opinion? How would it change the prosecutor's role, given they are responsible for seeking justice? Are we saying the Rhode Island state attorneys are not doing their job enforcing the law? I did ask the Attorney General's office if they felt they needed volunteer legal assistance with animal cases, and they were unaware of any issues when I spoke to them. Respectfully, I ask that you please review the testimony submitted to the committee by the Rhode Island Judiciary as to the significant negative impact these bills would have on the court system. And reading the Rhode Island court's analysis indicates that the organizations promoting these bills may very well have a broader agenda than what was likely communicated to the sponsors who filed them in the interest of protecting animals from cruelty, and even perhaps the individual Rhode Island residents that are asking you to support the bills. I thank you for your time.
Thank you very much. If you have other testimony that you need to finish up on, you had 3 bills. We're actually going to give you a little extra time, but does that complete your testimony?
I have submitted written testimony regarding concerns with Senate 319 as well, but these 2 bills are the ones that I intended to speak to this evening. But I am available for questions.
Thank you very much. I appreciate it. Any questions from any members of the committee, Ms. Ober? Hearing none, thank you for your testimony. You have a nice evening.
Thank you. You too.
Thank you. Our next witness is Pamela Aleppo, who's associated with Ms. Ober in the American Kennel Club. Good evening, Ms. Aleppo.
Yes.
Yes, welcome to the committee. You have 3.5 minutes, and you may proceed.
Okay. This is Pamela Aleppo. I am the current president of the Providence County Kennel Club. I'm also a lifelong dog owner, dog exhibitor. I participate in AKC sports. I'm against, I oppose the Bill S34 and S601, Lawyers for Animals. These are the reasons why. An animal advocate would be representing the animal's desires, which would be based on their own opinion. Animals currently are covered under the law for any kind of neglect or abuse. Adding this additional law would cause a lawyer or a lawyer student to make personal decisions on an animal which is considered personal property in the state of Rhode Island. With that being said, animals do not have the same rights as people. If the law is saying that they do, then they no longer can be somebody's personal property. So I think with that being said, the law is already covered in the current situation, and this particular law just adds constant need for interpretation of what it covers. I stand with AKC and I oppose this S534 and S601. Thank you.
Thank you very much. Are there any questions from any member of the committee for this witness? Hearing none, thank you. You have a nice evening.
Thank you.
You're welcome. Our next witness is Stephen David Say. Good evening, Mr. David Say. I'm not sure if I pronounced that correctly.
Stephen C.
Stephen C. Yes, please. You may proceed. You have 3.5 minutes.
Thank you. My name is Stephen C. I live in Providence, and I'm a lifelong dog owner and a lifelong dog fancier. I compete in dog sports with my dogs. Spending time with my dogs and taking excellent care of them is one of my highest values. Animal abuse is one of the most abhorrent crimes to me, and I support full prosecution of the criminals who commit those crimes. However, I oppose S-534 and 601, the Lawyers for Animals bills. Rhode Island courts appoint independent advocates to protect the legal rights of children or other people who are unable to manage their own affairs. S-534 and 601 would mirror this statutory text and extend it to animals. I'm opposed to any legislation that's predicated upon the idea that animals possess legal human rights or that animals are not property but legal beings. Changing the legal status of animals as property would ultimately hamstring the ability of owners, veterinarians, and government agencies to protect and care for animals. In short, I fully support the idea of animal welfare, but fully oppose the idea of animal rights. I'm available for questions. Thank you for the opportunity to testify.
Thank you very much for your testimony. Are there any questions from any members of the committee? Hearing none, thank you for your testimony. You have a nice evening.
You too.
Thank you. We're going to move on to Senate Bill 601, and our first witness is Hannah Stern with the ACLU of Rhode Island. Good evening, Ms. Stern.
Thank you, Chairman. I actually have 3 bills that I'm testifying on tonight.
Oh, yeah, so we'll give you,
I know I heard some other people doing that earlier.
That's okay. We're going to give you 5 minutes for all 3 of those bills. So go ahead. You may proceed.
Great. Thank you so much. I really appreciate it.
You're welcome.
Thank you, Chairman and members of the committee. I'll start by testifying on S-534 and S-601 together. My name is Hannah Stern, testifying on behalf of the ACLU of Rhode Island in opposition to both of these pieces of legislation. From our perspective, these bills just set a really problematic precedent, which we think should be rejected. In cases of alleged animal cruelty or abuse, the prosecutor is already the advocate of the animal. It would be unfair for a criminal defendant to instead have to defend themselves against 2 official accusers, both the prosecutor and this animal advocate. In these circumstances, the animal advocate's participation would really only stack the deck against a criminal defendant. And then finally, we just want to point out the state has a victim services unit for people who are alleged victims of serious crimes, which includes supportive services. But even these advocates cannot participate directly in the judicial proceedings against a criminal defendant. So we're very concerned that this legislation could lay the groundwork for a really dubious expansion of advocacy work directly into a criminal trial in a way that would really undermine the rights of criminal defendants. So again, we urge rejection of both of these pieces of legislation. Thank you for your time, and I'd be happy to take questions before my next bill.
Yeah, thanks. Let me just throw in there that I, as an active prosecutor, I've been prosecuting for several towns for a long time, one of them 14 years, and I've handled a whole bunch of animal cruelty cases. And I was thinking, right before you said it, of the fact that we have victims advocates in court that I rely on to give me input, feedback from victims and their position and how they want to handle things, but they can't actively participate in the trial or court proceedings. And I wonder if that change might enable this legislation to work. They're not my bills, but it would be nice, take it from a prosecutor, it would be nice to have an advocate in the court that could give me updated information that I didn't have from the ACO or the animal shelter or other people that are involved in the case. But I have to say, I'd agree with you that I think it's a little too far to have an advocate have a seat at the table in an adversarial proceeding. I don't know that that's the right thing to do. I haven't seen that in any other instance, and if we're not going to use it for domestic violence cases, I don't know that we should use it for animal cases. But I do think they could have a role like the advocates have in court now. I'm not sure what you think about that.
Oh, I'm sorry. I think the phone cut out. Were you still speaking?
Yeah, no,
Or-
sorry, I'm not sure what you think about that, what my comments were, but go ahead, you can comment on that if you want, or if, you could just move on. I'd be curious as to your input.
Yeah, I mean, I think that we would think that the expansion of advocacy work, again, like I said, into a criminal trial in this way, we just think would undermine the rights of defendants. I think we would feel similarly about the Victim Services Unit, but that's certainly something that I'd be happy to confirm and get back to you on.
Yeah, sure, no, that's okay. Go ahead, you may proceed, you can move on, thank you.
Thank you. Yeah. Thank you again, Chairman and members of the committee. Again, Hannah Stern testifying on behalf of the ACLU of Rhode Island in opposition to S309 this evening. Only 3 years ago, the General Assembly enacted very similar legislation to this bill. We just do not believe there's a compelling reason to make the penalties under this statute even harsher than they already are. A convicted individual is already restricted from possessing or residing with an animal for up to 5 years, but the penalties in this bill would forbid a person from a further multitude of animal-related actions for life, which we think concerningly just gives the court no discretion to really determine the terms of an appropriate and individually considered punishment. So just to give an example of something that we think would be a really inappropriate and unjust and very extensive punishment is under this legislation, a teenager convicted of cruelty to animals could not have a family 30 years later with a pet of any kind, regardless of their rehabilitation or their subsequent growth. Again, we just think this is really inappropriate. So the punishments already in place, we believe, are more than sufficient. For this reason, we urge rejection of this legislation. And thank you for your time. I'd be happy to take any questions.
Thank you very much. Are there any questions from any members of the committee, Ms. Stern? Hearing none, thank you. You have a nice evening.
You too. Thank you so much, Chairman.
Thank you. We're going to move on now to Senate Bill 806. And our first witness is Chalice Hobbs. Good evening, Chalice Hobbs.
Hi, yeah.
Hi, yes. Welcome to the committee. You have 3.5 minutes and you may proceed.
Okay, yeah, so I'm Chalice Hobbs. My great-great-grandfather started a fur farm, which my dad and my brothers operate today. I've worked on that farm. I grew up in the industry. I have more than 20 years of experience in it. I worked in it during my undergrad and while getting my MBA. I visited almost every single farm that is operational in North America. And in my opinion, from what I've seen and from my experience in agriculture, fur farming is very similar to other forms of animal husbandry and agriculture, such as poultry and cows, fish. It's the same processes. And I just wanted to inform you that from the breeding, the raising, and the harvesting of the animals, it's all done with regulations and certifications to assure the animals' welfare, so they are taken care of. And so I'm definitely in opposition of the bill, and I wanted to tell you these things because I think it's important, the source of the information you consider when choosing to oppose or support a bill like this. It's the same, for example, if you want to understand racism towards black people in America, you wouldn't go to a white supremacist just to ask if it was a problem. It's the same thing. You need to go to the source who actually is involved in the industry, such as the fur farmers, the Fur Commission, and the IFF, who I know are providing information as well, correct information. So yeah, I am in opposition of that bill, and I just wanted to express that.
Thank you, Mr. Hobbs. I appreciate your testimony. I will say that going to the source is part of the collective process, but personally, I like to hear from all sides. I don't find any one side to hold all the answers. I listen to everybody and then try to make up my mind. I have a question for you, though. You said your family's been in fur farming. That's not in Rhode Island, right?
I'm in Idaho.
Okay, I appreciate your testimony and you taking the time tonight. Let me see if anybody from the committee has any questions for you. Any members of the committee have any questions, Mr. Hobbs? No, thank you very much. Thanks for making the time to call in. You have a nice evening.
Thank you.
Thank you. Our next witness is Christina Scaringe from the Animal Defenders International. Not sure if I pronounced that correctly, Christina. Apologize if I didn't. Welcome to the committee. You have 3.5 minutes to testify, and you may begin.
Thank you, and good evening, Vice Chair. I'm Christina Scaringe for ADI and our Rhode Island supporters for Senate Bill 806, with thanks to the committee and to you, the Vice Chair, for your leadership on this measure. We have provided you extensive data in writing, including several ADI investigations revealing nightmarish fur industry standard practices, where animals' miserable lives in cramped, filthy cages meet brutal, abrupt ends. We also provided you a 2021 WHO FAO OIE report, concluding that SARS-CoV-2 spillover from fur farm animals to humans poses a, quote, serious public health and socioeconomic threat, and that specifically in the U.S., the likelihood of the risk of introduction and spread of SARS-CoV within fur farms is very likely, that the likelihood of SARS-CoV-2 spillover from mink fur farming to humans is very likely, and that the likelihood of SARS-CoV-2 transmission from fur farming systems to susceptible wildlife populations is likely. They also found a high occupational health risk at fur farms. Studies show the fur industry presents high climate and environmental costs as well, with significant emissions and land use requirements and pollutants emanating from animal waste, feed systems, incineration, and tanning processes. Another study we provided you concluded that compared with textiles, fur has a higher impact on 17 of 18 environmental themes, including climate change, eutrophication, and toxic emissions. In many cases, fur scores markedly worse than textiles. The climate change impact of 1 kilogram of mink fur is 5 times higher than that of the highest scoring textile. There are not many raw materials scoring this high per kilogram on climate change. That equals about a car drive of over 1,250 kilometers. As far as land occupation goes and on local air quality, fur scores far higher than other textiles. This study concluded that even in the conservative approach, the environmental impacts of 1 kilogram of fur are a factor 2 to 28 times higher than those of common textiles. They stated it was a very clear and consistent result, with indicator categories all pointing in the same direction. The Northern District of California recently dismissed a case by IFF against San Francisco. It was a constitutional challenge on a similar San Francisco ban, and they repeated their earlier holding that the Commerce Clause does not preclude these bans. The fashion world can and is already moving on. It's time to end this horrific practice. Please help Rhode Island join other leaders towards cruelty-free fashion innovation that recognizes and responds to the planetary crises of our time. ADI also supports and thanks the sponsor for Senate Bill 531. However, in the interest of time, I just refer the committee to our previously submitted written testimony. Thank you, and I welcome your questions.
Thank you very much, Mrs. Scaringe. I appreciate your testimony. Are there any questions from any members of the committee for this witness? Hearing none, thank you. You have a nice evening.
You too.
Thank you. Our next witness is Gail R. Hansen from the Humane Society Veterinary Medical Association.
Chair Archambault, and good evening, Vice Chair Archambault, and members of the Judiciary Committee, and
good evening.
Thank you for your time.
You have 3.5 minutes, so please go ahead. You may proceed.
Okay, thank you. My name is Dr. Gail Hansen. I'm speaking on behalf of the Humane Society Veterinary Medical Association and their 9,000 members nationwide. I have over 25 years experience in infectious disease epidemiology, 12 years in private veterinary practice, 5 years as a veterinary senior officer at the Pew Charitable Trust, and I'm a former state epidemiologist and state public health veterinarian for the Kansas Department of Health and Environment. I'm speaking in support of Senate Bill 806, the Rhode Island fur sales ban. Since this latest COVID pandemic began, I've been closely following the link between animals, specifically animals raised for fur, and the spread of SARS-CoV-2. That's the virus that causes COVID-19 in people. We already knew that mink, foxes, and raccoon dogs, all species farmed for their fur, were susceptible to infection with SARS-CoV-1 viruses, but now we know that SARS-CoV-2 has a particularly devastating impact on fur-farmed mink. And genetic analysis from the fur farms in the Netherlands and Denmark has shown that sick workers introduced SARS-CoV-2 to mink. The virus mutated in the mink, and then that new variant was passed back to people. There's also a possible case in Michigan of mink giving COVID-19 back to a person. Given the high density of animals and the stressful conditions they are enduring on the farms, it appears that the virus is mutating rapidly among the mink. There's also the possibility that the SARS-CoV-2 virus can not only circulate on the farms, but that the farms could also spread the virus to other species in the local environment. In fact, the virus was detected in the wild mink near infected farms both in Utah and Oregon. This creates potential for a reservoir for the disease, creates a long-term risk for the virus recirculating and mutating not only in mink, but in people as well. SARS-CoV-2 outbreaks on fur farms around the world represents a serious public health risk, and it's my expert opinion that this demonstrates the need to end the fur trade to protect the public. States like Rhode Island can be leaders in this by ending fur sales, and I hope you support Senate Bill 806. Thank you.
Thank you very much for your testimony. Any questions of committee members? Seeing none at this time, thank you for joining us. Next up, I believe we have Mike Brown from Natural Fibers Alliance. Good evening, Mr. Brown. You have 3 minutes and 30 seconds for your testimony. You may begin.
Yes, thank you so much. Dear committee members, thank you for the opportunity to comment on SB 806. My name is Mike Brown, and I represent the Natural Fibers Alliance. We are an environmental justice coalition that promotes the use of natural materials to include wool, leather, fur, and other animal-derived products. Now, despite a decades-long campaign against fur and other natural fibers by a small group of activists that has most recently included false narratives around mink and the spread of COVID, which, by the way, have all been debunked by both CDC and USDA, fur specifically receives significant support from the public that can no longer be ignored. Now, recent polling supports consistent findings from Gallup that more than half of Americans think wearing fur is morally acceptable. Among findings from a recent Natural Fibers Alliance sponsored poll, which included Rhode Island residents, 60% believe retailers should be allowed to sell real natural fur, while only 12% do not. Although a few brands have announced plans to phase out real and natural fur in favor of fake fur, these pledges cut against public sentiment on the use of real fur, as well as societal trends towards sustainability. It's no secret that synthetic plastic-based textiles, such as fake fur, are a leading cause of oceanic pollution. Continuation of current production and waste management trends are projected to result in 12 billion tons of plastic waste in landfills or across natural environments by 2050. The reality is SB 806 runs counter to the recent passage in the Senate of SB 0037, which bans single-use plastic checkout bags in efforts to protect our oceans and marine life. Legislators should support the public's desire for sustainability by increasing their use and support of sustainable natural fibers, not environmentally damaging plastics, which have all too long been supported by big business. Lastly, closing down small businesses at this time is counterproductive to Rhode Island's post-pandemic economic recovery. Why introduce legislation aimed at closing the same small businesses you're trying to protect, promote, and see prosper? I urge you to vote no on SB 806. Thank you, and I trust the committee will do everything it needs to do to protect Rhode Island's small businesses. Thank you so much.
Thank you for your testimony. Any questions of committee members of this witness? Seeing none at this time, thank you for joining us this evening. Good evening. Welcome to our committee. I believe we have P.J. Smith representing the Humane Society of the United States. You have 3 minutes and 30 seconds.
Thank you, Chair, Vice Chair, and committee members. I appreciate the time. My name is P.J. Smith. I'm the Director of Fashion Policy for the Humane Society of the United States. And along with our supporters across Rhode Island, we hope you'll support Senate Bill 806. For over a decade, I've worked with dozens of the top apparel companies, including Macy's, Michael Kors, Bloomingdale's, Gucci, and Prada, to create fur-free policies that are simply good for business. Just last month, Saks Fifth Avenue became the latest company to go fur-free, closing all of its fur salons. And last year, Nordstrom's stock jumped after they announced they were ending fur sales. These companies understand they're facing a changing consumer, one who rewards progress for animals, understands that there's no way to humanely source fur, and prefers animal-friendly alternatives.
no matter how the fur industry tries to spin it, it's not difficult to understand why consumers and companies alike are moving away from fur products. One, it's impossible to confine wild animals in a cage for their entire lives and expect good welfare. Two, keeping tens of thousands of animals on fur factory farms has a huge toll on the environment. And three, the fur trade is responsible for the spread of COVID-19, resulting in over 400 virus outbreaks on fur farms in 12 countries, including 4 U.S. states. Fur farm mink are the only species known to transmit the coronavirus to humans, and a mutated mink variant has been found in humans around the globe and among wild mink populations. Because so many companies have gone fur-free, and now cities, states, and even countries are looking to end fur sales, new innovative alternatives are paving the way for a humane marketplace. The new faux fur is corn-based and biodegradable, or it's made from recycled ocean plastic, which is better for the planet as well as animals. The few retailers that still might sell fur in Rhode Island will have time to transition to these materials and a more sustainable business practice. California ended fur sales in 2019, and just last year, Wellesley, Massachusetts became the first New England city to phase out fur sales. And now Massachusetts has introduced its own fur sales bill, ban of its own. And the United Kingdom is looking to become the first country to phase out fur sales. There's simply no place for fur products in a modern world. And with the passage of Senate Bill 806, Rhode Island will solidify its position as one of the nation's most humane states. It signaled to the rest of the world that it will not contribute to this cruelty or risk to public health. We hope you'll vote yes for this important bill. Thank you.
Thank you very much for your testimony. Any questions of committee members? Thank you. Seeing none at this time, we'll now move to our next witness. Good evening. Welcome to the Committee on Judiciary. I believe we have Mr. Bob Goldberg representing the Humane Society. You have 3 minutes and 30 seconds.
Thank you, Madam Chairman. Yes, Bob Goldberg here representing Humane Society of the United States and supporting S806. In the first instance, I'd like to thank Senator Archambault for sponsoring this legislation. He's been a long-time friend and supporter of animal rights, and I know the whole society appreciates the work that he puts in on this. This bill is supported heavily by the Humane Society, and I'd like to indicate, Madam Chairman and members of the committee, that we are working on some amendments to this bill to address the situation of, or the objection of business owners saying they're going to be hurt and put out of business. We expect to have some proposals very, very shortly in that regard. We're also looking at proposals to perhaps lessen the criminal aspect of the activities it seeks to prohibit. But what's at the core of this legislation is to try and prevent the immense, almost unmentionable cruelty that goes on to these animals they brutally slaughter to make these fur garments. And we'll be getting back to the committee and the sponsor very soon with suggested amendments. But the importance of this bill to the animal community, I cannot overstate. And I thank you for your attention.
Thank you for your testimony. Any questions of committee members? Yes, Senator Archambault.
Thank you. Thanks, Bob. I appreciate the kind words, and please let me know whatever input you may have and what changes you have proposed, and we'll do all we can to work with you. As I mentioned earlier, I did also talk to the representative from the DEM, and they had concerns over people who are trapping. You can trap and hunt in the state, so I think that might need to be a carve out.
We want
to
address that concern as well.
Thank you very much, Bob. Appreciate it. Look forward to working with you. You got it.
Thank you again for your testimony this evening.
Thank you.
Committee members, we're just waiting for the next witness on the phone. Just a minute. Good evening. Welcome to the Committee on Judiciary. I believe we have Alan Herskovich. Yes, you're representing truthaboutfur.com. You have 3 minutes and 30 seconds, sir, for your testimony.
Thank you very much. I'm testifying in opposition to S806. My name is Alan Herskovich, and I've spent the past 40 years studying and writing about the fur industry, most recently with truthaboutfur.com. I appreciate this opportunity to speak with you today because I'm deeply troubled that you're being asked to make an important decision based on some very misleading information. For example, in the findings introducing 806, the claim that fur animals, quote, endure tremendous suffering is simply not true. Those who say this have clearly never visited a fur farm. Farm-raised mink, in fact, receive excellent nutrition and care, and in fact, this is the only way you can produce the high-quality fur for which America is known. The statement in the findings that fur farmers use, quote, the cheapest killing methods available is also completely misleading. Farm-raised mink are quickly and humanely euthanized with bottled carbon monoxide. CO is so quick and painless that, unfortunately, as we know, many people accidentally die each year without even knowing they've been exposed to it. And it's also so unfair to claim that fur farms threaten, quote, public health because mink can contract COVID-19. In fact, with proper biosecurity in place, Dr. Anthony Fauci and the CDC have stated they do not consider mink farms to be a public health risk. Furthermore, a new COVID mink vaccine has now been developed, and vaccination of the U.S. mink herd is beginning as soon as the end of this month. The findings also fail to mention that many wild fur bearers would have to be culled, even if we do not use fur. Overpopulated beavers flood property, raccoons spread rabies and other dangerous diseases, coyotes prey on calves and lambs, and now even pet dogs and cats, and the list goes on. But if we have to cull some of these animals to maintain a balance, surely it's more ethical to use the fur than to throw it away. Finally, it's grossly misleading to claim that new alternatives render the use of fur, quote, unjustifiable. Most clothing today is synthetic, as we know, made from petroleum, a non-renewable and polluting resource, basically another form of plastic bag. Fur, by contrast, is produced responsibly and sustainably, despite some of the testimony you've been hearing from groups that have been dedicated to banning fur for a long time. A mink coat can be worn for 30 years or more. After decades of use, can be thrown into the garden compost where it'll biodegrade completely. Environmentalists are now telling us we should reject fast throwaway fashion, that we should be buying better quality apparel, keeping it longer. From this perspective, we should be promoting fur, not seeking to ban it. And those who support S806, I'm sure, have good intentions. But without accurate information, good intentions can have unintended and counterproductive consequences. Because despite the luxury image, the fur trade is really small artisanal industry that's been very unfairly scapegoated. It simply does not have the resources to fight wealthy, media-savvy animal rights lobby groups like you've heard from this evening. I don't think you have any idea how hurtful these sorts of statements and lies are to the farmers and the trappers and the fur artisans that are being criticized here. I don't know of any other group of people you can speak about in this way today at a time when we're trying to eliminate arbitrary and hurtful discrimination. It's become like fair game, politically correct hate groups. You can say anything you want about fur farmers and there's no consequence. I think that we have to think about that. No one's obliged to wear fur or leather or wool or to eat meat or dairy. These are very personal choices, and I don't believe it's appropriate or progressive to use legislation to impose these choices. So in conclusion, with respect, I would urge you to proceed very cautiously before you ban the sale of fur products, that you in fact attacking the livelihood and the cultures of people who live close to the land. Thank you again. Remember, too, last point, that there's already laws in place in America that ensure animal welfare and environmental security. There's a lot more about this in Truth About Fur. Thank you again for this opportunity to comment, and I'll be happy to answer any questions. But please remember, there are people here you're talking about, and it's not just vague ideas.
Thank you very much for your testimony. I do believe Senator Archambault does have a question.
I just want to thank you, Madam Chair. I want to thank you for your testimony. You're exceptionally respectful, very informed, and you have a lot of empirical experience behind what you're saying, and I personally appreciate that very much on behalf of this committee. I will also add that you raise an interesting point. Mr. Goldberg's going to work with the sponsors of the bill on some changes to it, but coyotes and beavers, other animals that are quite frankly classified as nuisance species and can be harvested year-round, I think there would need to be a carve-out for them, because it's already within the law that those animals can in fact be taken, and they're not part of the other classification. But I do appreciate your testimony and your caveat is well heeded. Thank you.
May I make just one quick? Thank you,
yes.
Senator. And
yes, you may.
Senator, thank you for that comment. And if I may say, I know it's not possible right now during COVID because mink farms, as you mentioned, they have biosecurity in place, which is how they have controlled the problems in America. But I would hope that yourself, who cares about this, and other members of the committee would absolutely visit an American mink farm before you proceed with this, and see for yourselves that it has nothing to do with the language we've been hearing from some of the animal rights groups we heard from tonight.
Thank you, sir, for your testimony. Any other questions of committee members? Seeing none at this time, we will now move to the next witness. Welcome to the Committee on Judiciary. I believe we have Michael Whalen, Fur Commission USA, on the line. You have 3 minutes and 30 seconds, sir.
Thank you, Madam Chair and committee members. My name is Michael Whelan, and I am the Executive Director of Fur Commission USA, the national trade association representing the U.S. mink producers. I am testifying in opposition to Senate Bill 806. Since August, when the SARS-CoV-2 virus first appeared in mink in Europe, we have been consulting with the USDA, the CDC, and the National Veterinary Diagnostics Lab on response and protocol development regarding the virus. When the virus appeared on U.S. farms, we worked closely with the various government health agencies and were able to limit the spread to a minimal number of isolated farms. Much has been said over the last few months about the presence of COVID in mink, mostly to promote bans on fur sales or production, using public health as the driving element. Working closely with the federal and state agencies responding to the 2020 farm infections, I have firsthand knowledge of the situation. By following the precautionary measures and protocols that have been provided to the farm community by the CDC, the USDA, and the state veterinarians, the virus did not spread from the isolated farms that were initially infected. Of the 16 farms that suffered outbreaks around the country, all have been cleared of live virus. No U.S. mink have tested positive for the virus since early January. The legislatures in the states of Oregon and Washington considered similar bills targeting fur over COVID fears during this present legislative session, and each rejected them on the basis that the scientific community agreed that farmed mink posed minimal threat to public health. These legislatures relied on testimony by experts directly involved with the response efforts, peer-reviewed scientific studies, and government agency recommendations. They rejected the sensational rhetoric, the cherry-picked studies quoted out of context, and the self-proclaimed mink experts presented by the animal rights community. Additionally, Zoetis, the world's largest producer of animal vaccine, has developed a vaccine for mink that has received emergency use authorization. Clinical testing on thousands of farmed mink proved it to be extremely effective, and approximately 2 million doses will be distributed to the farms over the next 3 to 4 weeks. Another 2 million doses will be ready by July 1st. This is enough for every farmed mink in the country to be inoculated. In regards to animal welfare concerns, for mink farmers in both the U.S. and Canada to sell their products at the international auctions, the farms must operate under strict animal welfare standards. The requirements for farm certification in the U.S. are detailed in the standard guidelines for the operation of mink farms in the United States, which can be found on the Fur Commission USA website. These standards have been peer-reviewed and endorsed by the Professional Animal Auditor Certification Organization, the same organization that certifies meat, dairy, and egg producers. Each farm is inspected for compliance by independent third-party auditors, and I can assure you that care standards for mink farming are as robust as any in animal agriculture. In conclusion, I can confidently state that COVID and farmed mink poses no threat to the public and should not be a factor in any debate regarding the sale of fur products. Additionally, mink are some of the best cared for animals in all U.S. agriculture. Humane care and animal safety is the American mink farmer's #1 priority. It is a moral obligation as well as good business. U.S. producers are in the top 5 to 10% in world prices because of the quality of their product, and that quality is a direct result of the quality of care their mink receive on the farm. Thank you very much.
Thank you for your testimony. Any questions from committee members? I don't see any at this time. Thank you, sir, for joining us this evening.
You're welcome.
Welcome to the Committee on Judiciary. I believe we have Joanne Barber from the Humane Society of the United States. Welcome, and you have 3 minutes and 30 seconds for your testimony.
Thank you, Madam Chair, members of the committee. My name is Joanne Borbo, and I'm the Northeastern Regional Director for the Humane Society of the United States. And on behalf of all of our supporters here in Rhode Island, I'd like to thank Senator Archambault for sponsoring this important bill and ask you to support S806, which would ban the sale of new fur products in the state. Rhode Island has shown time and time again that it does not support animal cruelty, and I'd like to focus my verbal testimony on the unimaginable cruelty inherent in this needless industry. There's simply no way to humanely produce fur. Every year, over 100 million animals, including mink, chinchillas, foxes, and raccoon dogs, are killed just for their fur. Over 80% of all fur comes from fur factory farms where undomesticated animals spend their entire lives cramped in cages, deprived of the ability to engage in natural behaviors. This intensive confinement, combined with the inability to exhibit natural behaviors ingrained in them as a wild animal, produces an enormous amount of stress, which leads to psychological disorders such as self-mutilation and stereotypical pacing. At the end of their short lives, mink are either killed by neck-breaking or crude gassing, and foxes and raccoon dogs are killed by anal electrocution. It has been well documented that animals are bludgeoned to death or skinned alive while still alive for the fur trade. I also want to note that the majority of fur products sold in the U.S. come from China, where there are zero animal welfare regulations for fur animals. Even in the U.S., there are no standards or regulations by the USDA or other state departments addressing animal welfare on fur farms. Any attempt to claim that fur farms are certified is the fur industry's attempt to greenwash animal cruelty. Any fur certification is simply a codification of existing abusive practices and doesn't address the serious animal welfare concerns inherent with locking an undomesticated animal in a cage. No matter how the fur industry spins it, the fact remains it's cruel to cram undomesticated animals into cages and anally electrocute or gas them to death. Fashion brands that have visited certified farms have determined that there is no way to humanely source fur and have chosen to go fur-free. The concern for animal welfare continues to grow in Rhode Island and across the U.S., and consumers increasingly want products that do not involve animal cruelty. There are so many innovative materials available now that are beautiful and sustainable, but more importantly, that do not involve inflicting pain, suffering, or isolation to any wild animal. So I'd like to ask for your support of S806.
Thank you for your testimony. Any questions of committee members? Seeing none at this time, thank you for joining us. Welcome to our committee. I believe we have Farah. You're going to have to pronounce your last name for me. I'm sorry.
No problem. Daruvar.
Please tell me your name.
Farah, and the last name is Daruvar.
Thank you for joining us. You have 3 minutes and 30 seconds for your testimony. You may begin.
Thank you very much. I wanted to say that I absolutely oppose this ban. I think as an American, being in this country, we all have the right to choose what we wear, what we eat, and what gender we are. And I believe that at this time, by banning something, we're taking many steps backwards. With the ban, you're not just banning fur in a shop. There are about 10, 15 businesses that correlate with selling a fur product. And all those businesses are run by small families. So the person that makes the pelts, the person that dyes the pelts, and then every part of the animal is used. If you're banning the use of fur, you will be probably banning seafood, shellfish. We all fall in the same category. The fish, vegetables, animals, we're all in the same category. And I believe that you're singling out the fur industry, and I don't think it's correct. We have taken every measure to make sure that everything is done. All the farmers are all under the same bracket as you do when you farm a fish, when you raise horses, cows, sheep, lambs, ducks. And unfortunately, I feel that we're being singled out. And I hope that you would also give me the time to give you in detail that it's not one industry and one boutique that you will be hurting. Those items are being sold in boutiques. They pay the salary of the person that works in the boutique, and they pay the rent of the store. And the luxury tax that the fur industry brings in for each state is very high. I had the pleasure of speaking to the legislative body in New York, and I said, if fur is banned in New York, the entire trade will, let's say, move to New Jersey. And therefore, all the taxes and all the businesses will follow there. And I believe that Rhode Island, you guys have come maybe further than a lot of other states. And I hope that you will understand that instead of banning us, you should support small businesses. And I appreciate very much your time and letting me speak and testify.
Thank you very much for joining us this evening and for your testimony. I don't see any questions of committee members. Thank you again. Welcome to the Committee on Judiciary. I believe we have Melanie Calandra with us from the International Fur Federation's Americas region.
That's right.
Yes, you have 3 minutes and 30 seconds for your testimony, ma'am.
Thank you, Madam Chairman, members of the committee. Thank you for the opportunity to testify against the proposed ban, SB 806. My name is Melanie Calandra, and I'm a Managing Director at the International Fur Federation. I'm here today as you and your colleagues have been given a great amount of misinformation about the fur trade that is simply false. The fur trade in North America is a small-scale, family-run, artisanal industry. Fur provides vital income for remote indigenous communities who are limited in their options for creating income. Fur farming has strict animal welfare standards with third-party audits. Fur farming is sustainable. Everything is used. You might be surprised to know that fur farming takes over 50,000 tons of food waste a year, diverting it from landfill. Manure is used for fertilizer. Mink oil is used as biodiesel. Everything is used. In previous testimony, animal extremists have tried to claim that fur farms threaten public health because mink can be susceptible to COVID-19. In fact, with proper biosecurity and quarantine when necessary, Dr. Anthony Fauci and the CDC have stated that they do not consider mink farms to be a public health risk. Fur farmers deserve your support. Wild-sourced fur is well regulated at the regional, state, and federal levels with 2 ISO standards and international agreements on humane trapping. The United States currently has the best wildlife management model in the world as a result. Instead of banning a natural, sustainable product, I'd like to propose that Rhode Island adopt a traceability system for fur and take a look at FurMark. FurMark is the global certification and traceability program for fur. FurMark is a collective effort to deliver global standards. It ensures that each step of the production process meets strict requirements which reflect various globally recognized animal welfare and sustainability standards. FurMark means sustainability, it means transparency, it means traceability, and it means animal welfare. Be the first state to implement global standards for the fur trade. Support this historic resource-based trade today. In closing, I strongly ask you to reconsider SB 806.
Thank you very much for your testimony. And any questions of committee members? Seeing none at this time, thank you for joining us.
Thank you.
Welcome to the Committee on Judiciary. I believe we have Donna Ann Corvo on the line. Ma'am, you have 3 minutes and 30 seconds for your testimony.
Okay, thank you so much. I actually thought I was going to miss out on doing this. I thought it was a Zoom that I didn't get an invitation for. So thank you so much, committee members. And I just want to say that, I'm a lifelong resident of Rhode Island. My husband and I own a business in Rhode Island, and we appreciate the opportunity to voice our opinion, and just wanted to kind of urge, the Senate to pass and support the Bill 806 so that we can ban the fur in Rhode Island, at least at the start. And I just wanted all of the members, if they didn't already know, to just be educated about what actually happens to these animals on these fur farms. And of course, there's plenty of undercover video from, animal advocacy groups that can be seen online, and it is graphic and it is horrifying, and it's just so unnecessary. And, these poor innocent animals that have done nothing wrong to anybody live a life of just pure hell, and, then they're violently killed with no sedation or anything, because, of course, the fur farms want to make as much profit as possible, so they, they're typically skinned alive with no mercy and just left to die. So if there's, any way that we can get this passed and kind of, show that Rhode Island doesn't believe in cruelty to animals, and hopefully the rest of the country will continue to follow suit. I know California has already. So I did have a lot of other things that I wanted to kind of say, but like I said, I'm driving right now, and this is unexpected. But I do thank you, and I do hope that everyone can find it in their hearts to understand the severity, of this and the importance of stopping it. And the reason why I mentioned I was a business owner in Rhode Island was I certainly am sensitive to, fur businesses that will have to close, but there are plenty of alternatives, faux fur and other, products that are superior to animal fur that, they could market instead, and probably win over a lot more critics if, they could market their product as, cruelty-free. So it doesn't mean it goes, they go out of business. They just have to change the business. So thank you again, and I hope that everyone will support the bill and looking forward to the outcome.
Thank you again for your testimony this evening. I do not see any questions at this time. Thank you for joining us.
Okay, thank you so much for the opportunity.
You're welcome. And I believe that is our last witness of the evening. Thank you for your patience. And if I could have a motion to adjourn us by Senator Archambault and seconded by Senator Rogers.
By Senator Cassad.
And Senator Casada and Senator Burke. Thank you very much. All those in favor?
Aye.
Aye. And we are adjourned. Thank you.
Thank you. Good night.